All right, guys, welcome back to the channel, the Butterfly Monkey Effect. This is going to be the 6th video on this passport document by the government. I want to apologize for how I had to leave abruptly the last video. I didn't get to make a comment about the court case, right, which is this one right here, where they basically deny the person a passport because he was a pauper. Because he was dependent on contributions, not only from regular people, but from the government themselves to try to be able to travel back and forth on whatever he wants to do. And that's why they denied him that. Now, what we read, that right, was a dissent. So, like, the dissent is in agreement with, like, what I would think, like, should have happened, right? Where he should have gotten a passport and all this, and these are the reasons why it's unconstitutional. But the ruling, right, because right here they give the explanation, right, why the Secretary of State, even though they didn't tell them, right, is through the court cases, the Secretary of State, look, this is my reason right here, right? But, and then the judge, he gives his opinion. He flat out says that, you know, that it's his discretion. And the way he says is, where's the part at? Says the point can be made clear by reversing arguendo the situation. Suppose France, Italy, and some other country knowingly issue passports to panhandlers for the purpose of letting them travel around this country, begging their way. Would such a practice be in the best interest of the country issuing the passport? So that's the thing. It says, so he goes, I am of the opinion the Secretary of State has a measure of discretion in the issuance of passports. Foreign relations are involved. And that's the key thing. Foreign relations, right? We're sending, if we were to grant him a passport, we're sending a pauper over there. A poor person who can't afford shit, by his own words. You know, by his own words. Foreign relations are involved, and such relations lie largely within the good judgment of the executive branch. In Schachman versus Dulles, we said, for reasons thus suggested, the issuance of passports throughout our history has been left to the judgment of the Secretary under presidential regulation, and is subject only to constitutional safeguards. And even these must be defined with cautious regard for the responsibility of the executive in the conduct of foreign affairs. The ground upon which the Secretary acted in the case at bar seems to be both rational and reasonable. It sucks, but they're looking at the national context, foreign relations and all that stuff, sending a pauper over there, someone that would be dependent on their government or their citizens. That in itself just sounds fucked up. So sorry I didn't give you that commentary at the end. I got a phone call right before I ended the live, so the recording. So the next case is Dayton versus Dulles, September 13, 1956. And it says also see Dayton versus Dulles 357, United States Code. Well, this is below, so it's coming up. I don't know if they're going to talk about both. So it's per curiam. The Secretary of State denied a passport to appellate Dayton, who then sued in the district court for a declaratory judgment that he is entitled to a passport and that the Secretary's passport regulations and certain rules of the Board of Passport Appeals in the Department of State are unlawful. The motion of the Secretary for summary judgment was granted. That of the plaintiff was denied, and the complaint was dismissed. We held Dayton's appeal undisposed of pending our en banc disposition of Bowdoin. So that's the case, not the one we just read, but the one before that. As in the Bowdoin cases, the Secretary of State rested the denial of the passport upon section 51.135 of the regulations without specifying, however, upon which of the three subsections of said section he relied, and without any finding sufficient to bring the applicant within any one of said subsections. When the case was pending in the district court, however, an affidavit was filed in support of the Secretary's motion for summary judgment. And this affidavit stated that the refusal of the passport was under subsection C of said regulation. The affidavit also contained a finding stated in the terms of that subsection. 1. In the Bodine cases, we accepted for purposes of the opinion the affidavit filed in the district court as a statement for the reason for the Secretary's denial of the passport. But the better practice requires that the denial itself, rather than an affidavit filed in court after litigation over the denial has arisen, should specify the regulation upon which it rests and should contain such findings as are called for by our Bodine opinion. Here, as in the Bodine cases, the Secretary is denying the passport advised the applicant that the denial was on the basis of evidence which included confidential reports of investigation. In requiring reconsideration by the Secretary of the Bodine cases, we said inter alia that we did not reach Bodine's contention that the Secretary could not rely on confidential information, but we added, and here repeat as applicable to the Dayton case. Since that question may arise at a subsequent stage, we find the Secretary should, if he refuses a passport after the further consideration we have ordered, state whether his findings are based on the evidence openly produced or in whole or in material part on the secret information not disclosed to the applicant. If the latter, so this is they're repeating this. If the latter, the Secretary should explain with such particularity as in his judgment the circumstances permit the nature of the reasons why such information might not be disclosed. This will facilitate the task of the courts in dealing with the question of the propriety of the Secretary's use of confidential information, a question which, we repeat, we do not reach. For those reasons above, and more fully explained in Bodine opinion, the judgment herein reversed, and the case is remanded to the district court for further proceedings not inconsistent with this opinion. It is so ordered. Brio versus Dulles, 1957. Below, and then Powell versus U.S. versus Powell, 1957. It says below with quotations, but they don't give nothing, so I don't know. The three defendants are charged in a 13-count indictment with engaging in seditious activities intended to adversely affect the armed forces of the United States while the United States was at war with Korea from July 1950 to July 1953. During the entire period of the Korean War and for several years prior thereto, the defendant John Powell was the owner and editor of the defendants. Sylvia Powell and Julian Schumann were staff members. Was the owner. Okay, they don't say the business, but was the owner and editor. So he's a publisher. Sylvia Powell and Julian Schumann were staff members of a magazine published in Shanghai, China, and known as a Chinese Monthly Review. The false and derogatory statements which the indictment charges that the defendants circulated fall into four principal categories. 1, statements that the United States was the aggressor in the Korean War. 2, statements that the United States was waging bacteriological warfare in Korea and China. 3, statements that the United States was stalling and disrupting peace talks and was deliberately breaching the armistice agreement. And 4, statements relative to the number of United States casualties in Korea. You would think this would fall under freedom of speech. The false statements charged in the indictment thus center around events in China and Korea. Ever since the indictment was returned in 1956, the defendants have faced a unique problem in obtaining for use at their trial evidence in their defense, which they claim is available to them in China and North Korea. The United States has never recognized the government of the People's Republic of China, which since October 1st, 1949, has controlled the Chinese mainland. Since May of 1952, the United States Department of State has not issued passports valid for travel to China. The United States does not recognize the People's Government of Korea, which controls North Korea. Since October 1955, the United States Department of State has not issued passports valid for travel to North Korea. So in today's day, they can't do that no more. They could still, okay, so they're not giving you the national context of why they would be able to not give you a passport to go there, all right? But they cannot stop you from going there. They could just restrict you from using the passport to go there, right? The passport is their property. They're restricting your travel there based on some national context. But there's nothing stopping you from traveling to, say, Mongolia and then going to China on your own. But you can't use the passport. That's the thing that people need to understand. Counsel for defendants have repeatedly sought the assistance of the court to facilitate counsel's travel to China to gather evidence for the defense. Yeah, you think they're really going to come back? On January 24, 1957, defense counsel by affidavit advised the court that the People's Republic of China had refused to grant Mr. Weirin a visa to enter China unless his United States passport was validated for travel there. They moved the court to direct the State Department to validate Mr. Weirin's passport for travel to China. At the hearing of the motion on February 1st, 1957, they also moved that alternatively the court dismissed the indictment. The record shows that despite the intensive efforts made by counsel for defendants to obtain access to evidence assertedly available in China and North Korea, no substantial progress has been possible. The necessity for defense counsel to travel to China and North Korea in preparation for trial has become manifest. And this is the counsel. This ain't like the defendants themselves, right? The indictment puts in issue the truth of the statements allegedly circulated by defendants through the Chinese Monthly Review, as well as the intent with which the statements were made. Evidence tending to show that the statements were true and that they were made in good faith in the belief that they were true and without criminal intent is obviously essential to the defense. Since defendants resided in China during the period covered by the indictment and for a number of years previously, and since the events which they are charged with falsely reporting occurred in China and Korea, it is evident that China and Korea are the most likely sources of any such evidence. The record discloses that Attorney Weirin has been denied passport clearance to Communist China and Korea by the State Department. The record also shows that if Weirin's passport is validated for travel there, he can enter Communist China and Korea and proceed to pursue his duties there as defense counsel. As stated in the order of March 20th, the policy of the State Department as to the issuance of passports to Red China and Korea is not subject to judicial review. So let's remember this. As stated in the order of March 20th, the policy of the State Department as to the issuance of passports to Red China and Korea are not subject to review. In this proceeding, at least, nor can we judicially or do we question the wisdom of that policy, which may be in the best interest of the people and government of the United States. In this case, and in resolving this motion, we are concerned only with the problem whether the defendants are deprived of their constitutional rights of due process and of fair trial by the acts of the United States, which prevent counsel from gathering evidence for their defense in the Chinese mainland and North Korea. The difficulties and indeed the impossibility of examining witnesses and appraising their worth other than by going to China and Korea is shown in the affidavits and is self-evident. The Constitution, Amendments 5 and 6, grant the right to defendants in criminal case to have compulsory process, to summon witnesses, and to counsel to aid in their defense, and to due process. Under the issues made by the indictment and the defendant's plea of not guilty, if there were diplomatic relations between the United States and China North Korea to proceed with the trial without permitting defense counsel to interview the summoned witnesses abroad would clearly violate the constitutional provisions. The unique problem tendered is whether it is any less a deprivation of constitutional rights under the circumstances of this case. The United States has commenced and is prosecuting this criminal proceeding against the defendants, and the indictment charges in many counts false statements made and circulated by the defendants with intent to hinder and obstruct the armed forces of the United States. The defendants have the constitutional right to present evidence that the statements alleged to have been made and circulated were not false and not published or circulated with criminal intent. This evidence lies abroad in Red China and North Korea. They can at least have the opportunity to try to obtain this evidence. If the United States issues a passport to Attorney Warren, valid for travel to and in Red China and North Korea. Without it, the rights granted by the Constitution become meaningless. So the United States has its choice. It can choose to adhere to its policy of non-issuance of such passports, or it can decide that it is more important to prosecute this criminal case. If the former be its choice, it will mean a discontinuance of the present prosecution. The government has cited United States versus Von Clem, wherein the prosecution of a criminal case to trial was permitted even though the procurement of material defense evidence abroad was impossible. And that's the thing. They said impossible. We don't know if it's impossible yet, or if they come to that conclusion. But that case is not apropos. Apropos? What's that? I'm not going to delete and change that one. A little laggy today. Apropos. Apropos typically functions as an adjective describing what is suitable or appropriate. Or as a, let's go, appropriate, apropos legal. With regard to or concerning. Where did I just leave off at? But the case is not apropos in regard to or concerning, whatever. But for it was not within the power of the United States to make possible the obtaining of foreign evidence. The opposite is the case here. And that's my point. But the cause should not be dismissed without a final opportunity for the United States to decide its course. Hence, the following ordered, unless the United States validates the passport of Attorney Warren for travel to and in China and North Korea, within 30 days from date, the indictment will be dismissed. The order setting the cause for trial on December 2nd of 1957 is vacated. In the event the United States elects to validate Mr. Warren's passport, the cause, as appropriate motion and notice, may be reset for trial. So it's like, okay, we'll go get them the evidence and then, start all over or something. I don't know. So this is part 6. I know it's going to be more court cases, but we'll see. I don't know why that scratched out, but so I guess part 4, the Supreme Court at issue with the Secretary of State. Ooh, Kent versus Dulles. In June of 1958, the United States Supreme Court in Kent versus Dulles and Dayton versus Dulles, which is the second one, right? They told us to read both, right? That the following was both. So finally decided the issue respecting whether or not the Secretary of State has discretion to refuse or issue a passport to a citizen of the United States. Well, they didn't say the context. Finally decided the issue respecting whether or not the Secretary of State has discretion to refuse to issue a passport to a citizen of the United States. The issues has been framed below in Brill versus Dulles, where the extensive majority and dissenting opinions covered the historical, legislative, and constitutional background. In that decision, the Court of Appeals had upheld the discretionary power of the Secretary of State to refuse passports to citizens who were alleged to be communist. The appeals court also decided Kent versus Dulles on the same day and on the same basis in the brief opinion. And I give you the other citation. See also Stewart versus Dulles, where the secretary was ordered to decide the merits and had refused to proceed to a decision in the administrative process, although plaintiff had repeatedly filed statements under oath which were material, though not the sort of statement the department had been urging. Because of the importance of the question involved, the Supreme Court opinion, including dissenting in Kent versus Dulles and Dayton versus Dulles, as well as the subsequent opinions of Aptheker and the Secretary of State and Zemo versus Rusk, below are set out at some length. Further, the Supreme Court recently, in April 1966, granted certiorari in the case of Travis versus the United States, see below, which involved the main questions in these cases, although area restrictions affords the vehicle for review. So A, Kent versus, let's look at the annotation first. For a complete opinion, including dissenting opinions, see appendix. And that's what the majority of this book is, the appendix. So a 298-page book, easily 150 pages or more are the appendix. The court combined the similar case of Brill versus Dulles with that of Kent for the purpose of its decision, since the issues were the same. The court stated the facts of the two cases as follows. The case concerns two applications for passports denied by the Secretary of State. One was by Rockwell Kent, who desired to visit England and attend a meeting of an organization known as the World Council of Peace in Helsinki, Finland. The director of the passport office informed Kent that issuance of the passport was precluded by 51.135 of the regulations promulgated by the Secretary of State on two grounds. One, that he was a communist, and two, that he had a consistent and prolonged adherence to the Communist Party line. The latter of denial specified in some detail the facts on which those conclusions were based. Kent was also advised of his right to an informal hearing under 51.137 of the regulations. So they're giving him a remedy, an administrative remedy. But he was also told that whether or not a hearing was requested, it would be necessary before a passport could be issued to submit an affidavit as to whether he was then or ever had been a communist. Kent did not ask for a hearing, but filed a new passport application listing several European countries he desired to visit. When advised that a hearing was still available to him, his attorney replied that Kent took the position that an affidavit concerning Communist Party membership is unlawful, and that for that reason and as a matter of conscience, he would not supply one. He did, however, have a hearing at which the principal evidence against him was his book, It's Me, O Lord, which Kent agreed to was accurate. He again refused to submit the affidavit, maintaining that any matters unrelated to the question of his citizenship were irrelevant to the department's consideration of his application. The department advised him that no further consideration of his application would be given until he satisfies the requirements of the regulations. Dr. Walter Briel was a psychiatrist. When Briel applied for a passport, the director of the passport office asked him to supply the affidavit covering membership in the Communist Party. Briel, like Kent, refused. The director then tentatively disapproved the application on the following grounds. In your case, it has been alleged that you were a communist. Not are, but you were a communist. Specifically, it is alleged that you were a member of the Los Angeles County Communist Party, that you were a member of the Bookshop Association, St. Louis, Missouri, that you held Communist Party meetings, that in 1936 and in 1941, you contributed articles to the communist publication Social Work Today, that in 1939, 40, and 1941, you were a sponsor to raise funds for veterans of the Abraham Lincoln Brigade in calling on the President of the United States by a petition to defend the rights of the Communist Party and its members, that you contributed to the Civil Rights Congress bail fund to be used in raising bail on behalf of convicted communist leaders of New York City, that you were a member of the Hollywood Arts, Sciences, and Professions Council, and a contact of the Los Angeles Committee for Protection of Foreign-Born, and a contact of the Freedom Stage Incorporated. And you know, it's funny about that, the Hollywood Arts, Sciences, and Professions. All right, well, if you understand who dominates, what class of persons dominate that culture, that society over there, right, are the same ones who are communist in Russia at, 20 years at least before this. Well, all the way through, all the way until it was overturned, right, until it was overthrown, right? But nonetheless, it's the same class of people who committed the genocide in Russia. All you have to do is go look that up, see who they are and what they did. The director advised Briel on his right to a hearing, but stated that whether or not a hearing was held, an affidavit concerning membership in a communist party would be necessary, and that can't be true. Briel asked for a hearing, and one was held. At that hearing, he raised 3 objections. 1, that his political affiliations were irrelevant to his right to a passport. 2, that every American citizen has the right to travel regardless of politics. And 3, that the burden was on the department to prove illegal activities by Briel. Briel persisted in his refusal to supply the affidavit. Because of that refusal, Briel was advised that the board of the passport would not, under the regulations, entertain his appeal. And this is the main thing, right? This argument, I'm going to highlight this whole thing because these are his arguments. Both Kent and Briel filed suit in the United States District Court, which granted a summary judgment against Kent and dismissed the Briel case from the ground that his case was indistinguishable from that of Kent. Both cases were heard together by the Court of Appeals, sitting en banc, which I think en banc just means from scratch, from the start, right? Which affirmed the district court's decision. Thereupon, the Supreme Court granted certiorari. So it's going to the Supreme Court, right? But they said that both Kent and Brill filed suit, which granted summary judgment against Kent and dismissed Brill's case on the ground that his case was indistinguishable. So they went against him. But now they're going in the Supreme Court. In the Supreme Court, Mr. Justice Douglas delivered the opinion of the court with Justice Mark Burton Harlan, which to me, if you guys don't know who Judge Harlan is, that's a truth teller right there. Assuming this is the same judge, 1960. It's probably not the same judge, right? Because the Harlan I'm talking about is the Harlan from like Downs versus Bidwell, right? That's a 1901 case. So, but man, just seeing the name, for me, that's a truth teller. So, to each their own. And Whitaker dissenting, with Justice Clark, Burton, and Harlan, and Whitaker dissenting. In its opinion, the majority first stated the function of a passport in American law. The court first noted the function that the passport performed in American law in the case of, and that's the one I can't pronounce, Tetique versus D. Arbo, right? And this, I was going to say 1980, this is 1895, right? There is no law of the United States in any manner regulating the issuing of passports or directing upon what evidence it may be done or declaring their legal effect. It is understood as a matter of practice that some evidence of citizenship is required by the Secretary of State before issuing a passport. This, however, is entirely discretionary with him. No inquiry is instituted by him to ascertain the fact of citizenship or any proceedings had, which will in any manner bear the character of judicial inquiry. It is a document which, from its nature and object, is addressed to foreign powers, purporting only to be a request that the bearer of it may pass safely and freely, and is to be considered rather in the character of a political document by which the bearer is recognized in foreign countries as an American citizen, and which by usage and the law of nations is received as evidence of the fact. It is noted the great value and necessity of a passport abroad, but stated that throughout most of our history, indeed, until quite recently, such a document was not a legal requirement for leaving or entering the United States. The court pointed out that apart from minor exceptions, it was first made a requirement by Section 215 of the Act of June of 1952, which states that after a prescribed proclamation by the President, it is unlawful for any citizen of the United States to depart from or enter or attempt to depart or enter from the United States unless he bears a valid passport. The necessary proclamation has been made. The court then noted some of the laws enacted and decisions, rulings, and regulations by the executive department concerning them. Excuse me. The court stated, let me get some water real quick. The court stated, finally, in 1856, Congress enacted what remains today as our basic passport statute. Prior to that time, various federal officials, state and local officials, and notaries, public, and had undertaken to issue either certificates of citizenship or other documents in the nature of letters of introduction to foreign officials requesting treatment according to the usages of international law. By the Act of August of 1856, Congress put an end to those practices, which I think I said before, right? Man, notary used to be able to do that stuff. They stopped that. They wanted to make it more, they wanted to consolidate that power. Part 2, 877 reads this. The Secretary of State may grant and issue passports under such rules as the President shall designate and prescribe for and on behalf of the United States, and no other person shall grant, issue, or verify such passports. Thus, for most of our history, a passport was not a condition to entry or exit. It is true that, at intervals, a passport had been required for travel. Mention has already been made of the restriction imposed during the War of 1812 and during the Civil War. A like restriction, which was the forerunner of that contained in the Act of 1952 Act, was imposed by Congress in 1918. Hold on, I'm reading something. Okay, the Act of May 22nd, 1918 made it unlawful while a presidential proclamation was in force for a citizen to leave or enter the United States unless he bears a valid passport. So here they changed it and made it a statute in 1956. But in 1918, it was a presidential proclamation, right? Under a specific context. What is it? World War I. See House Resolution Report number 485, 65th Congress. That statute was invoked by presidential proclamation on August 8, 1918, which continued in effect until March of 1921. The 1918 Act was effectively only in wartime. It was amended in 1941 so that it could be invoked in the then existing emergency. I don't know what emergency. Well, World War amended in 1941, which is World War II. So 55 Stat 252. See Senate Report number 444, 77th Congress, first session. It was invoked by Presidential Proclamation 2523, November 1941. That emergency continued until 1952. Congress extended the statutory provisions until 1953. It was during this extension period that the Secretary of State issued the regulations herein complained of. I'll highlight all this. It's a history of it. So it's like, plus I'm probably going to go read those acts as it is. Under the 1926 Act and its predecessor, a large body of precedents grew up which repeated over and again that the issuance of passports is a discretionary act on the part of the Secretary of State. The scholars, the courts, the chief executive, and the attorneys general all said so. This long-continued executive construction should be enough, it is said, to warrant the inference that Congress had adopted it. And they give you citations. I don't know none of these cases. But the key to that problem, as we shall see, is in the manner in which the Secretary's discretion was exercised, not in the mere fact that he had discretion. And that's what I'm saying. It's the limitation. But I want to read these court cases anyway. So highlight these court cases. The right to travel is part of the liberty. of which the citizen cannot be deprived without due process of law of the Fifth Amendment. That's, I think, procedural, right? And the 14th is substantial. So much is conceded by the Solicitor General. In Anglo-Saxon law, that right was emerging at least as early as the Magna Carta. Chaffee, Three Human Rights in the Constitution, 1956, that book right there. Bam. You know, gotta try to get that book too. My goal for a lot of these books, I haven't technically started yet. I did buy equipment to build the thing, but I want to make and print my own books. I want to make my own book, not really print, because all that is off a computer, right? But I want to be able to bind my books. So I bought the stuff and shit to make the equipment for it, but I haven't gotten around to it, man. And I have a stack of PDFs. I really would like a book, and that process is really time consuming. So I don't know what I'm going to do. I do know I'm going to do some, because some are worth making copies of. So Chaffee, Three Human Rights in the Constitution, 1956, shows how deeply ingrained in our history this freedom of movement is. Freedom of movement across frontiers in either direction and inside frontiers as well was a part of our heritage. Travel abroad, like travel within the country, may be necessary for a livelihood. It may be as close to the heart of the individual as the choice of what he eats or wears or reads. Freedom of movement is basic in our scheme of values. And they got Crandall versus Nevada, which people should be familiar with, right? It's based on citizenship stuff. Williams versus Fears, Edwards versus California, which these are I'm gonna make cases on these. Probably Crandall too, right? I'm gonna make videos on them. On probably Crandall also. And the thing, if you watch the other videos, which of course, if you're on part 6 by now, right? What did they tell you traditionally how it was in Europe, right? They weren't allowed without permission to leave the country. But even though it had the right to travel within the country was enforced, right? Was a thing, right? We adopted that here too. But we also adopted the furtherance of it, meaning because we are sovereign, right? We're not subjects like they were. We are sovereign. We don't have to ask for permission, which is why they stated earlier, it was never needed to leave. It never was. You always have to ask for permission from the other country. Just because they stopped a notary from being able to write a letter of introduction or granting of a passport doesn't change the fact that you still have the power to be able to go there just by asking them. Our nation, wrote Chaffee, has thrived on the principle that outside areas of plainly harmful conduct, every American is left to shape his own life as he thinks best, do what he pleases, go where he pleases. Man, I'm going to just highlight this whole thing right here. Really? Freedom of movement also has large social value. As Chaffee put it, foreign correspondents and lecturers on public affairs need first-hand information. Scientists and scholars gain greatly from consultations and with colleagues in other countries. Students equip themselves for more fruitful careers in the United States by instruction in foreign universities. Then there are reasons close to the core of personal life: marriage, reuniting families, spending hours with old friends. Finally, travel abroad enables American citizens to understand that people like themselves live in Europe and helps them to be well informed on public issues. An American who has crossed the ocean is not obliged to form his opinions about our foreign policy merely from what he is told by officials of our government or by a few correspondents of American newspapers. And if you really pay attention, that's what they're trying to do to us right now with the conflicts in Israel, with the conflicts in Ukraine, right? They are purposely not showing us anything of what's going on over there. The only thing that you find is what? Independent journalism. That's what you find. And then even to the extent that that reporting is being restricted on whatever platform you might be on. It's on purpose. They only want you to view their view, even though they know it's unconstitutional what they're doing. To prove it is the other thing. You can see it. It's a fact. When all you have to do is watch Channel 2 News or something, Channel 5, Channel 7, whatever. And there you go. Do you see it? They offer you nothing. Almost damn near nothing. And then half the segment, right, will be about irrelevant stuff like someone's cat and dog and, crap that no one cares about. Except to the effect that it touches somebody's feelings or something. Moreover, his views on domestic questions are enriched by seeing how foreigners are trying to solve similar problems. In many different ways, direct contact with other countries contributes to sounder decisions made at home. And see Vesto, freedom of movement. See, look at this. These Iowa law reviews, all this stuff, man. The reason why this is important, right, to not only understand what he's seeing, right, which is an author of authority, right, or these law reviews, right, which are authors of authority, it's because they're using them in court. They are principles of law that these judges are using in their opinion, because opinion is defined to be used that it has to be used. What's the word? What's a good word to use? The definition for opinion has a criteria to it that must be followed, using rules of statutory construction, using principles of law. You guys heard me say this before. You know what I'm saying? Like, this is why Black's Law Dictionary and stuff is not used at first. It is used like left, right? Meaning they went through a process to find what a word means, right? From the plain language, right? Reading the context. If you can't figure it out, well, let's go look at the intent of Congress, right? And if it still can't be figured out, then it just keeps trickling down the line. That's when the dictionaries come into play. Otherwise, those ultimately don't mean shit. It's no different than any other regular dictionary. You just have to use it, right, for reference, for knowledge, education, and so forth. But understand that the context, the thing that you're researching and reading, is where it's at. You only use that as a last-ditch issue, a last-ditch effort, because you have no other choice. You looked everywhere else. Freedom to travel is indeed an important aspect of the citizen's liberty. We need not decide the extent to which it can be curtailed. We are first concerned with the extent, if any, to which Congress has authorized its curtailment. I want to highlight that stuff too. I'm probably going to highlight this whole page like a jackass. Freedom to travel is indeed an important aspect of the citizen's liberty. We need not decide the extent how it could. Okay, I reread that. The difficulty is that while the power of the Secretary of State over the issuance of passports is expressed in broad terms, right? Because the statute does not give you the context. It was apparently long exercised quite narrowly. So far as material here, the cases of refusal of passports generally fell into two categories. First, questions pertinent to the citizenship of the applicant and his allegiance to the United States had to be resolved by the Secretary, for the command of Congress was that no person shall be granted or issued to or verified for any other persons than those owing allegiance, whether citizens or not. And you know, this right here, okay, understanding that at the time when this type of language came out, we had no territories, meaning there was no Puerto Rico, no American Samoa, or nothing. The only territories that were applicable were Indian tribes. But they fall under this category. At least I think they would be eligible for a passport. They are under our protection, right? And so forth. Those categories of you know, owing allegiance, whether a citizen or not, falls there. 32 Stat 386, which that's the literally basic definition at 212. But they have also 22 USC 212 and 212A. Second, with the question whether the applicant was participating in illegal conduct. So this is the intent of Congress. But over the years, right, because of the word discretionary, these people thought that they could do whatever they want and deny a person for whatever they want. Was participating in illegal conduct, trying to escape the toils of the law, promoting passport frauds, or otherwise engaging in conduct that would violate the laws of the United States. See Moore International Law Digest, 1906. Hackworth Digest. So like, these are books that I for sure want. What the hell? Come on, really? Well, these are books that I want. The grounds for refusal asserted here do not relate to citizenship or allegiance on the one hand, or to criminal or unlawful conduct on the other. Yet so far relevant here, those two are the only ones which it could be fairly argued that adopted by Congress in light of prior administrative practice. One can find in the records of the State Department ruling of subordinates covering a wider range of activities than the two indicated. But as respects communists, these are scattered rulings and not consistently of one pattern. We can say with assurance that whatever may have been the practice after 1926, at the time the Act of July 3rd, 1926 was adopted, the administrative practice, so far as relevant here, had jellied only around the two categories mentioned. We therefore hesitate to impute to Congress when in 1956 it made a passport necessary for foreign travel and left its issuance to the discretion of the Secretary of State, a purpose to give him unbridled discretion to grant or withhold a passport from a citizen for any substantive reason he may choose. And that's ultimately what's wrong. But let me oops. The court then pointed out, give me a second. The court then pointed out that the more restrictive regulations were applied in 1918 and 1941 as war measures, and that it was not compelled to equate this present problem with problems that may arise under the war power. It cited Korematsu, with the Japanese guy, where the government in time of war had been allowed to exclude citizens from their homes and restrict their freedom of movement only on a showing of the gravest imminent danger to the public safety. But they did that shit to so many fucking people that man, they violated so many fucking rights. There's absolutely cause that they could do that, right? But man, in some contexts, they just can't. You know, like what they're doing now with the immigration stuff too. No doubt, it's racial profiling. No doubt, right? Within 100 miles of a border, right? They have the power to ask you or require you to identify yourself for the purposes of immigration, not after those hundred miles. That don't apply no more. So them pulling people over, just stopping them randomly, right? That's bogus in and of itself, trying to get them to prove it to themselves. Don't get me wrong, it's a trial and error thing. They're hoping that they got someone that's illegal, right? But man, they're doing that to citizens too. They have lawsuits. 100% we could stand on our ground and they will have a lawsuit because there is no, I haven't read nothing in no proclamation or executive order where shows that authority has changed. So for whatever that's worth, you know what I'm saying? Let me get pulled over and I'll find out. I told my girl already about that. That like, I'm not giving them shit. I'm going to let them do whatever they got to do. I'm not giving them shit. I'm going to let them violate all their rights. It stated that the nation was at war and that Congress and the chief executive moved in coordinated action, but that no such condition presently exists. No such showing of extremity, no such showing of joint action by the chief executive and the Congress to curtail a constitutional right of a citizen has been made here. You can't tell me this is not a beatdown right here. Finally, the court stated, since we start with an exercise by an American citizen of an activity included in constitutional protection, we will not readily infer that Congress gave the Secretary of State unbridled discretion to grant or withhold it. If we were dealing with political questions entrusted to the chief executive by the Constitution, we would have a different case. But there is more involved here. In part, of course, the issuance of a passport carries some implication of intention to extend the bearer diplomatic protection, though it does no more than request all whom it may concern to permit safely and freely to pass, and in case of need, to give all lawful aid and protection to this citizen of the United States. But that function of the passport is subordinate, meaning it's like a privilege. I'm going to say it's more of a privilege. They don't have to do that to some extent, right? Its crucial function today is control over exit. And as we have seen, the right of exit is a personal right included within the word liberty as used in the Fifth Amendment. If that liberty is to be regulated, it must be pursuant to the lawmaking functions of the Congress. And they give you a court case. Youngstown Sheet versus Tube Company versus Sawyer, Supra. I don't remember them saying that one. And if that power is delegated, the standards must be adequate to pass scrutiny by the accepted test. See Panama Refining versus Reagan and more. See, this is what I would have to use. Fuck. Were activities or enjoyment natural and often necessary to the well-being of an American citizen, such as travel, are involved, we will construe nearly all delegated powers that curtail or dilute them. Ex parte Endo and C. Hannigan Esquire. United States versus Rumley. We hesitate to find in the broad generalized power and authority to trench so heavily on the rights of the citizen. Thus, we do not reach the question of constitutionality. We only conclude that Section 1185 and 211A do not delegate the secretary the kind of authority exercised here. We deal with beliefs, with associations, with ideological matters, right? That's in your mind stuff, right? No criminal activity stuff. We must remember that we are dealing here with citizens who have neither been accused of crimes nor found guilty. They are being denied their freedom of movement solely because of their refusal to be subjected to inquiry into the beliefs and associations, into their beliefs and associations. They do not seek to escape the law nor violate it. They may or may not be communist, but assuming they are, the only law which Congress has passed expressly curtailing the movement of communists across our borders has not yet become effective. It would therefore be strange to infer that pending the effectiveness of that law, the Secretary has been silently granted by Congress the larger, the pervasive power to curtail in his discretion the free movement of citizens in order to satisfy himself about their beliefs and associations. Man, this right here is powerful, bro. To repeat, we deal here with a constitutional something, the citizen, right? Of the citizen, constitutional right of the citizen, a right which we must assume Congress will be faithful. I don't know. We would be faced. You got to read I'm going to guess you have to read the court case for this. Which seems it's Braille, right? It's the Braille case. Man, did I read that? I don't recall it. We would be faced with important constitutional questions were we to hold that Congress by Section 1185 and 211A had given the Secretary authority to withhold passports to citizens because of their beliefs or associations. Congress has made no such provision in explicit terms and absent one. The Secretary may not employ this standard to restrict the citizen's right of free movement. And they reversed the trial. Well, for sure, the appellate court. The dissenting justices wrote their opinion presenting the opposite view, upholding the right of the Secretary to exercise his discretion in the issuance of passports. To me, I think it's good to read those dissenting opinions, right? To see how strong they are, what it is, right? How is it that there's no crime, especially when Congress has gave two specific criteria: citizenship and criminal activity. You know, so it's like their dissent has to be like in respect to that. Outside of that, they're inserting their own ideology. That's how I would look at it. And that's where you get the concept of that courts are making the law. Because they're going off of what the intent of Congress is, or a principle of law. They're offshooting from that, and you can't. So hopefully you guys enjoyed that. Next will be, of course, Dayton versus Dulles. This one right here lasted a little bit over an hour, so that kind of sucked. I was hoping for more of a 45 minutes. This is an hour and 3 minutes, but I think it's still worth it and stuff. So hopefully you guys could go through it. Like I said in all other videos, put that at 1.5 speed. Get your brain to start working at a faster speed to research. And I tell you right now, that will save you hours upon hours of time in your research. I don't know how else to put that. All right. So hopefully you guys liked and subscribed and enjoyed what you guys have heard and read. For sure, this document you guys could get yourself, right, on Google Books just by searching it, right? So subscribe to my channel, subscribe to my TikTok, come follow me on Telegram, and ask me questions, man. Only one way to push further. Research and asking questions. That's always the thing. All right? Have a good one, guys. Till next time.